Hey everyone, Joe Russo here from the Granite Law Group. We handle catastrophic injury all the way down to run-of-the-mill motor vehicle collisions in New Hampshire and Massachusetts. And I wanted to do another video for you to discuss what happens when there's a liability dispute in a motor vehicle collision claim. Now, don't be deterred by the insurance adjuster telling you that they're disputing liability. This is what happens. Number one, insurance companies are in the business of paying you as little money as they can get away with. So if they have an opportunity to come up with a defense or dispute a claim, they're going to take advantage of that. That doesn't mean that's going to be their position throughout the duration of the case. What they go to initially is what is listed in the police report. Oftentimes, the responding police officer will determine who's at fault and put that in the narrative of the police report. Here's something that the insurance companies don't tell you. That police report is 9 times out of 10 not going to be admissible in trial, okay? It's hearsay. The police officer wasn't a witness to the actual accident. He's collecting his information based on accounts of other individuals. Those individuals would need to testify live at a trial. So the police officer's assessment of who's being truthful and who's not, or who's at fault and who isn't, is not going to be dispositive at all. Now, different situation if there's a full-blown accident reconstruction, which involves expert training and calculations, and if there's a scientific method for determining fault in a motor vehicle collision. But we're not talking about that example right now. We're just talking about your basic police report. It's not going to come in as evidence. So if the insurance company denies a claim based on the report issued by the police, and if I have a client who's saying to me, this is the way it happened, they didn't get my side of the story, I'm not at fault, here's why, we oftentimes will take the case, assuming that the injuries are significant and there's meat on the bone for us to work with. Now, in the state of New Hampshire, which is primarily where we practice, it's a mandatory mediation jurisdiction. And in Massachusetts and New Hampshire, they follow comparative fault rules of negligence, where you view the case as a full pie, one of those pie charts, 100%. So if a jury determines that your case is worth, let's just say round figures, $100,000, and you are 25% responsible, then you're only able to recover $75,000. If a jury finds that you are more negligent than the other party in a motor vehicle collision, if you're 51% and they're 49%, you get 0, okay? So in these disputed liability fact patterns, there's often a lot of wiggle room to play with when you're trying to get full value for your case. And the reason that I mentioned that mandatory mediation is our standard in New Hampshire is because oftentimes if a case is denied on liability grounds right out of the gate by the insurance adjuster, and your client is telling you that he or she didn't do anything wrong, we're willing to duke it out in litigation, because at the end of the day, 2 people are going to have to be deposed, give depositions in the case. Both parties are going to be subject to cross-examination. And if your client is very emphatic and is credible and the other person is not, that's going to heavily tip the scales when it comes time for that insurance adjuster, who originally just relied on the police report, to now do a more thorough assessment of who's being forthcoming and who's not. In addition to that, there's also some evidence that could disprove what people are testifying about. Oftentimes, property damage tells a tale that is a lot more compelling than witness testimony. It discusses point of impact, who had the opportunity to avoid a collision, where, what what portion of the car was first struck. It tells volumes about who had the duty to yield, who had the right of way, etc., when there's no other evidence besides the testimony of two parties. That's very important. If you live in a jurisdiction that is urban, there's going to be a lot of video surveillance that's potentially available that you could obtain through FOIA requests through that local city Department of Public Works or what have you. You could obtain traffic cameras. You could pull 911 calls and track down witnesses that otherwise weren't named in the police report. So there's plenty of things that you could work on to build up the value of the case. The whole purpose of this video is to tell you, do not be deterred because the insurance adjuster tells you right off the rip that you don't have a case because the police report tells you X, Y, Z. At the end of the day, the police officer is not going to testify in your case. It's going to be the testimony of you versus the other motor vehicle operator, and it's going to be on your lawyer to discredit the credibility of the other side and come up with any other evidence that tips the scales in your favor. And even if the case doesn't go all the way to trial, if you're able to effectively perform and execute your theory of the case throughout the course of depositions, at least in the state of New Hampshire, you're going to be able to sit down in front of a mediator and negotiate for some real numbers on your case. So if you have a disputed liability case and you feel like you're getting taken advantage of by the insurance adjuster, we'd be happy to chat with you and strategize to see if there's any workarounds to try to get some justice and some value on the matter. I'm going to leave a link below in the video. Please contact our firm. We'd be happy to chat with you. Again, happy holidays, Merry Christmas, and I'll talk to you soon.